We'll call the next case Orange County versus Willis. Morning, Counsel.
Good morning. May it please the Court. My name is Eric Netcher. I have the privilege of representing Orange County along with trial counsel Clay Morris. I'd like to reserve 5 minutes for rebuttal. Directed verdicts are designed to ensure that jury verdicts are not reached by conjecture and speculation. The trial court erred below by directing a verdict, by failing to direct a verdict and permitting the jury to reach a verdict that was based on such conjecture. That was an error for two.
Let me ask you this. You argue this case as it's an impermissible stacking of inferences. What inference would the jury have had to make other than that the county employees didn't put the manhole cover on properly and it remained that way until Miss Willis fell in?
The stacking of inference argument is an alternative argument. So our first argument is that this was not a reasonable inference that could be made in the first instance. But to your question...
Wait, it wasn't what?
That this was not a reasonable inference that could be made in the first instance in light of the fact that it was up against direct, uncontradicted testimony that the manhole cover was in fact secured. And I've cited Marlowe Investments.
What happens, what do we do with the fact that the jury heard all that evidence and testimony? Maybe they just didn't believe it. The jury can disregard testimony that's presented, even though it may not be rebutted, can't they? They can give it whatever weight they want to give it, right?
The jury certainly always has the prerogative to determine whether or not a witness is telling the truth. And in the classic he said, she said case, where we have a circumstance where one person says one thing,
You have county employees that are testifying. Yeah, we did everything right, and we complied with all the duties of our job, and the jury just didn't buy it.
At the end of the day,
the jury heard all of that evidence and testimony, and that's essentially what they said when they rendered their verdict, didn't it?
but at the end of the day, there was no direct testimony. There was no evidence presented by the plaintiffs, and it's their burden at the end of...
Four Fingers question then. I mean, there was, this lady fell on this manhole cover that was improperly secured. And his question to you was, what other inferences do you need to draw other than it was left that way by the county employee who didn't properly secure it?
Well, like I said, the manhole cover, the maintenance was performed in March. This accident occurred 2 months later, so we would have to infer that it stayed that way. Nobody fell, despite the plaintiff's testimony that she walked the exact same path every single day during this time frame. So we have to infer that...
Not stepping on the manhole cover, though, right?
That's correct. Well, presumably not stepping on the manhole cover. We don't know if perhaps she stepped on the manhole cover at a point in time when it was secured after the Orange County employees were there. We also know that citizens of average strength can remove these manhole covers, and it's been done in the past. There's a testimony of Mr. Burt who said that at times Orange County has been called out to ensure that manhole covers are secure after citizens had removed them.
And was there any evidence as far as documentation of the number of times the county had gone out to any location to secure manhole covers? And, you know, I guess the inference there was you got people running around unseating manhole covers. So was there any direct evidence presented documenting the need to go out and secure unseated manhole covers?
There was no direct evidence on that point, other than the testimony of Mr. Burt, who says that in the past this has occurred, and Orange County has been called out to secure manhole covers. Again, they weigh 50 pounds. It doesn't take a feat of strength. There was testimony that it can be removed by hand. They can be removed by screwdrivers, and with the direct testimony of Mr. Quigley, who said, "Listen, they were all secured when we left on that date." Never in their careers, these three individuals testified, had they left a manhole cover, and that it's a pretty simple process. They move it into place, they stand on it, and then they leave. So, I want to emphasize, this is not a premises liability case. That's the import of the directed verdicts on the premises liability issue and on the mode of operation issue. Those two theories could have...
It's a direct negligence case. Did they comply with their duty to reasonably secure the manhole cover? The employees whose job it was to make sure that they did that said that they did, but the testimony of the plaintiff was that it was unsecured, she fell through it, and she injured her leg.
Right.
So, the jury heard all of that evidence and testimony, and we have to assume that they just didn't by the testimony of your employees that they properly secured it.
The testimony of the plaintiff was that she had no knowledge as to whether or not it was left secured in March. Now, if we look at...
Testimony was that she stepped on it, she fell through it, it wasn't properly secured, and it was a breach of the duty of care, and that's what caused her injury.
That's right.
And then your employees come along and say, "Oh no, we had secured it. It was all properly done." And so the jury hears that, and they decide in her favor.
Well, there's no...
Apparently, they just didn't believe the testimony of these employees that said that they did it right.
There's no dispute that the manhole cover was ajar in May. That is what the circumstantial evidence that's presented at trial by the plaintiff establishes. And the circumstantial evidence...
Isn't that sufficient evidence for the trial judge to say, let the jury decide this issue?
It's not, and it's not... So? It's not because of the rule that when there is direct evidence that proves the contrary, the inferences from circumstantial evidence must evaporate.
Well, you have to take the evidence in the light most favorable to the non-moving party, right?
That's correct.
Okay. And so the evidence was that she stepped on this manhole cover. It was not properly secured. She injured her ankle, and the county was the one that was in charge of the manhole cover and properly maintaining it, right?
We have to take reasonable...
So you have to take that evidence in the light most favorable, and all reasonable inferences must be drawn in favor of the non-moving party. And the trial judge said, well, okay, let the jury decide. It's a jury issue.
You're absolutely right that we have to take all reasonable inferences in the light most favorable to the non-moving party. The problem here is it's not a reasonable inference to conclude that the Orange County employees left it ajar in March simply because it was ajar in May when she fell. And that's because of the cases that I've cited in the reply brief dealing with the nature of circumstantial evidence when it combats up against direct testimony on the dispositive issue of fact. And it is true that Orange County had control and maintenance of this property. But again, this is not a premises liability case. The ownership of the land is not what determines the liability here. This is an active negligence case, and left to prove that. That was the dispositive issue of fact that the plaintiff had to prove, that they failed to secure it in March. And the only evidence on that was that it was indeed left secured. And that is consistent with it being unsecured in May, given, as I've said, the fact that it's open to the public. They have access to it. It's a populated neighborhood. The area surrounding the manhole cover was next to an adjacent home. The grass was mowed. So there was no complaints at all about a jar manhole cover during this 2-month time frame. And the plaintiff, again, testified that she walked the same path every single day.
But she testified that she avoided stepping on the manhole cover, and she took a little bit different route this time, and she stepped on it, unfortunately, and she was injured because it wasn't properly fastened. So
help me with the evidence now. There were 3 employees from Orange County that testified. Am I correct that it was only Quigley who said that, I remember this manhole cover and it was put on correctly? The other 2 guys said, yeah, I remember being in the neighborhood and our usual practice is to put them back, jump on them, and that's it. But nobody but Quigley had a memory of this particular manhole cover.
That is correct, Your Honor. The other two,
Quigley's testimony was pretty brief, but he said, we wouldn't leave one ajar. We would, I drive around the neighborhood and I look at the manhole covers and I can see if they're ajar. I guess I come back to the question that Judge Sawaya asked, and if the jury, was the jury free to reject? It seems that the best evidence that you've got that we left it in place was from Quigley. Was the jury free to reject Quigley and say, look, he couldn't possibly, there's thousands of manhole covers, I assume, in Orange County, and he may know what his normal practice is, but there's no way that he could remember this particular manhole cover. Could the jury reject that if they chose to?
assuming that they rejected it, we're still left with the circumstance of we don't have evidence that it was left secured in March by the Orange County employees. We have the circumstantial evidence that it is ajar in May.
Well, there's no circumstantial evidence. I mean, there's no question that it was ajar in May, is there?
But we have the direct evidence that it's ajar in May, but it's circumstantial to the extent that plaintiff is trying to have the jury infer that because it's ajar in May, that it was left in that state in March by the Orange County employees.
But again, I come back to my question. Your case is premised upon what you call an impermissible stacking. And I'm just trying to see, could the jury reasonably reject the testimony of Quigley, who I think was the best witness for the county? Could they reject his testimony and then simply conclude that they left it ajar in March and it stayed that way until she fell in?
If they reject the testimony of Quigley and they assume, based off of the circumstantial evidence that it was ajar in May, that it was left in that state in March, that still doesn't get us to causation, because we have an intervening 2 months where, again, it's open and access to the public. We have individuals walking in this neighborhood. So the causation doesn't get us there. There could be other causes that resulted.
Causation is usually a question of fact for the jury in almost every negligence case. So if you want to talk about causation, to me, the trial judge definitely did the right thing in sending it to the jury. To me, it seems whether they breached the duty of care, the standard of care, the testimony was that they didn't. And you've got the testimony of the employees that say that they secured it properly, or at least one of them said that. And the jury heard all the evidence and testimony, and they decided to believe one side over the other.
That's true, Your Honor, based off, as we submit, conjecture and speculation in light of the fact that this was not a reason.
I don't see any stacking of inferences here either. I mean, you've got the direct testimony of the lady that fell on the manhole cover. It was improperly secured. That's the reason she fell in it. The county was in charge of properly maintaining this manhole cover. And
again, I'd point out, Your Honors, that this is an alternative argument, the stacking of inferences. I don't think that rule even needs to be invoked here in light of the fact.
Counsel, here's my question. What evidence was presented at the trial court level that it would be reasonable to assume that anyone but the county employees would have any reason to open the manhole, pull the cover off, and then improperly secure the manhole cover?
We have the testimony of, like I said, Mr. Bird, who testified that this has occurred in the past. We've had individuals and citizens that have come out.
That's just a general accusation, correct? Without any documentation.
And at the end of the day,
You have the statement that it's a 52-plus pound manhole cover with a general statement that you could remove the manhole cover without tools and with your bare hands. I haven't tried to do that recently, but I mean, was there any demonstration how you could do that with your bare hands, picking up a 52-pound manhole cover that I would assume is a pretty tight-fitting, heavy device, correct?
there was a video actually played of Mr. Burt lifting it with his finger, I believe, either that or a screwdriver, that was presented to the jury as a demonstrative during the course of the trial, and there was testimony to that effect that he could indeed lift it with his finger and he could lift it with a screwdriver. And I'd point to Gelco Convention Services versus Pettengill. It's a 4th DCA case from 1998, and that involved a convention service company that was putting on a convention, and a plaintiff was struck by a falling curtain divider that was installed by the convention service provider, and there was two theories of liability. This was either defective equipment or improper equipment. And after the defendant had installed the curtain wall, the hotel could do anything with it. They could move it. It was essentially under their control at that point. The hotel had access to it. And there was just no sufficient evidence in that case to support a verdict, because, as the court said, the first inference, which must be drawn from circumstantial evidence, was that Gelco was negligent, and there was no direct evidence of this. And again, I have to emphasize again, this is not premises liability. We're not holding the county liable because they maintain the property. Their maintenance of the property doesn't come into effect. The analysis would essentially be the same if a neighbor was brought into this case and they said, you shouldn't have done this. Maybe the neighbor that was adjacent to the property. So the point is, there was no direct evidence of negligence, and the circumstantial evidence upon which plaintiffs sought to have this jury infer that the county employees left it ajar in March was not reasonable in the face of the contrary direct evidence. The inferences from that.
I think there's a difference between cases where the property owner has direct control over the item or the thing that causes the injury. And in this particular case, where the only entity that had proper control and maintenance of this particular manhole cover was the county. I think there's a clear distinction, because you can turn control over to the thing that caused the injury to a property owner, then it becomes a property owner's responsibility. But here, there's no evidence that anybody other than the county was charged with maintaining this manhole cover and making sure that it was properly secured, right? Isn't that a distinction?
That is certainly a distinction, but at the same time, the manhole cover could be accessed by anybody, and that's the point. And if I could, I'd like to reserve the balance of my time.
All right, thank you, counsel. Good morning.
Morning, may it please the court. My name is Nick Shanine, and together with my partner, Carol Shanine, we represent the appellee in this matter, Sandra Willis. As this court has already explored during oral argument, there is no stacking of inferences here. There was but one inference, that the manhole cover, storm drain cover, was not properly replaced by the county less than 2 months before the plaintiff walked across it and fell into it.
Does the analysis change if she had fallen in 12 months after they had been out there to clean it out? Does the amount of time change that? I mean, how does the analysis change, if at all, if she had fallen in the next day, 2 months later, or a year later?
That's an excellent question, Your Honor, and the reason why is because it goes to the heart of why it is that there is no stacking of inferences, that we keep hearing 58 days, 2 months, that this could have been the very next day and there would have been a time interval, or it could have been 5 years later and there would have been a time interval. What that time does is certainly allows the jury to decide which reasonable inference should be drawn from this. If it had happened just 2 or 3 months after the county was out there, it's a pretty darn reasonable inference that the county is the entity that didn't do this. If it were 7 years prior, the jury would probably be caused to second guess that inference. And so, Judge Wallace pointed out that there was no testimony of teenagers running amok through the neighborhood, moving manhole covers. I would like to meet a man who could lift a 50-pound manhole cover with his finger. And it's not 50 pounds, it's more than 50 pounds. And we did have the testimony at the trial that the paramedics saw the firefighters use a special tool to move the manhole cover back into place after they had come to help with the accident. That this is not a everyday occurrence or anywhere close to it that we experience in our common lives to see manhole covers being moved by ordinary citizens or anybody else.
Quigley testified, it seems like his testimony was the best for the county. We put it back on. I don't remember if I was the one that stomped on it, but I was there, I remember this manhole, and we did the same thing that we always do. We stick it back on and we jump on it to make sure it's secure. I mean, that testimony isn't inherently incredible anything like that, and, he wasn't impeached in any way beyond how do you remember this manhole versus
Sure.
every other manhole. Was the jury free to reject that not inherently incredible testimony?
I, in many other cases, wish that were the standard, that not inherently incredible means the jury has to accept it. For right or for wrong, that is not the standard. The jury is free to accept or reject any testimony, including expert testimony. There are many, many cases that have been presented to this court where every medical examiner says, this person's injured, this person's injured, this person's injured, and yet the jury goes, no, we don't agree with any of those experts. That person's not injured, and this court will affirm those results because the jury, that's the reason why all of these cases, the Murphy case, the Marriott case, the Pastruca case, keep saying that this is a call for the jury to make. And here, obviously, Mr. Quigley had motivation to want to justify the way that his group did the job. There's also the fact, as this court pointed out, that there were 3 people who were out there, and yet only one of them could remember this manhole cover. And the jury was certainly fair to take the inference that if the other 2 couldn't remember it, why is it that the third one somehow could? And here's the other thing. There was no other indicia as to why he remembered it. He couldn't say that, I remember this hole specifically because, and then bring up some anecdotal evidence. And in today's age, where everybody walks around with a camera, everybody's got it, it would be the simplest matter if it were something that the county or anybody else desired to do to simply take a picture every time. They do the manhole cover, put it on, Bob, you stand on it, snap. They could do that each time. If there was that kind of evidence, that would have been something the jury would have been very interested in. But instead, we were stuck with the musings of someone essentially saying, I locked the door every time. The door must have been locked. I know I turned the oven off because I always turn the oven off. These are things that we do in our common day in practice, and certainly most of the time that's correct. But it's absolutely the province of the jury, not the judge, and not an appellate court on review, to override a jury's determination as to which witness is credible, which reasonable inference is to be drawn from a single inference. And here, where we have...
Do you think if she'd fallen in a year later or 5 years later, would that still be a jury question?
I do. I think that it would remain a jury question. I think, again, a jury would be a lot more hard put upon to find a reasonable inference that it was the county's failure that remote in time, but the proximity here within 2 months of the occurrence certainly enabled the jury to make that call. The judge correctly, and the judge took great pains to give full argument to the stacking of inferences issue, even though the cases that are being brought out are often very disparate in factual content, be it beans and rice on a floor somewhere or construction involving water. In any instance where there was a stacking of inferences found by the court, there were clearly 2 or more actual different levels of inferences. Here, there's but one. And the jury had to make that call. The jury did make that call. It's also notable that the jury also said, yes, it was ajar, and also, yes, Miss Willis, you should have seen it. And we're going to tag you with 50% comparative negligence as a result of that. That was the jury's call, and the jury's allowed to make that call as well, and we're not appealing that. But that is why the case law has been uniform from this court, in Pastruca and Marriott and Etheridge, that these are the types of decisions that must go to a jury, and when a jury does make that decision, when there is but one inference, there is simply no basis for which an appeal can rightly follow. So for each of these reasons, the appellee, Sandra Willis, respectfully requests this court to affirm the decision of the jury and affirm the decision of the trial judge to allow that jury verdict to stand. Thank you.
Thank you, sir.
Very briefly, Your Honors, what I heard is an effort to shift the burden to the defendant to show that we were not negligent. And that's not what the law requires. The manhole cover weighs 50 pounds. Judge Wallace 52 pounds was the testimony. Judge Wallace, at page 1,180 of the record is where the testimony came in that they can be removed with a finger or a screwdriver. And briefly on the Marriott case and the Petruskis case, I just wanted to discuss those very briefly. Both of those, again, were premises liability cases. The Marriott case was, the directed verdict was inappropriate because of the fact that, the denial of a directed verdict was inappropriate because of the fact that the defendant had to get over the two-issue rule. It involved a circumstance where the plaintiff was walking from her hotel to another hotel in light of the fact that there was no rooms left at the hotel she originally registered at, and she fell into a drainage inlet. Now, she brought 4 theories of liability: active negligence and 3 premises liability cases. Theories. Now, the court, an opinion by Judge Sawaya, appeared to sort of agree with the defendant on the active negligence issue, that there was no duty. But because the jury...
Well, there's a duty here because you can see that the county had the duty to properly maintain the manhole cover to make sure that it was properly secured. The question is, did they breach the duty? You frame this in the issue of causation, which is, to me, almost always a jury question. So it seems to me the issue in this case is, did the county breach the duty of care?
Absolutely, and that is the issue.
And so if there's when you're talking about motions for directed verdict, if there's reasonable inference to be drawn in favor of the non-moving party, the trial judge does it and lets the jury decide it.
The issue, absolutely.
So, but you're saying that there's an inference upon an inference. I don't see the other inferences, but
That is an alternative argument. The issue is the breach, and there was no evidence of a breach that was competent to get to a jury in light of the rule that circumstantial evidence and the inferences therefrom must fall in the face of contrary direct evidence. In a case cited by the plaintiff in their...
I mean, I don't even know that I see this as a circumstantial evidence case because there was direct evidence that it was improperly secured, she fell through it, and she injured her ankle, and that the county had the duty to properly maintain it.
I believe even in the answer brief...
If you say that's a circumstantial evidence case, I think that your definition of circumstantial evidence in mine is a little bit different.
That certainly would be direct evidence in a classic premises liability case, but the issue here was whether or not they actually left it ajar and marked.
I don't think that's, I think that's direct evidence in a active negligence case like you're asserting here, or like they've alleged here.
I think...
I really do. Anyway.
Respectfully, I just want to close by saying I think what we're left with here is a mystery as to who improperly removed the manhole cover, who didn't secure the manhole cover. The only direct evidence as to whether or not that was the county employee's testimony. And again, it was the plaintiff's burden to show direct negligence on behalf of a county employee. With that, we would respectfully request that this court reverse and remand for entry of judgment in favor of the county. Thank you
So much. All right, we're going to take a short recess now.